Attorney Kip from Malek. Just a kind of a brief I've talked about this before in other videos, and it's worth mentioning. Light duty job offers. I get calls, and the reason why I want to talk about this is because I've gotten calls, and I've had claims of light duty job offers that just seem basically a recipe to get somebody. I mean, the employer is clearly they're trying to get somebody booted. That's the whole point of the job offer. And so what I mean is, in a situation like this, you have a work injury, you have your doctor releases you work with restrictions, your employer ostensibly makes a good faith light duty job offer, and then the issue is you have to take that light duty job offer, and if you don't, then one, you're not working, you're not making wages, and then two, you're not getting temporary total disability because you refused a light duty job offer. And so, not not a particularly uncommon situation is, and this is a recent call, and I mean this has happened before too, but a situation where somebody gets injured, they gets released back to work with restrictions, and then they're put into a bare room with a desk and facing the wall with a clock. And a recent situation I encountered was the person was returned to work and the restricted duty involved that individual sitting in a wheelchair at a table facing a wall for I think like 8 hours, and they were prohibited from using their cell phone, smartphone. They couldn't access it, and then weren't allowed to sleep. Obviously, if you're at work, you're not allowed to sleep. But they didn't have anything to do. So, unless it's a great opportunity to get into meditation, but I imagine about 99.9% of the people aren't interested in getting into Zen Buddhism or whatever as part of their light duty job offer situation. So the issue becomes, you're basically going to either fall asleep or you're going to access your phone or do something that you're not supposed to, and then they're going to boot you. And so, there's that case, Pacheco case, and that's going to the Supreme Court, and I don't know if that's going back down to the 10th District Court of Appeals, but that was the big case that is going to define what good faith means in terms of an employer's light duty job offer. So this is my question, my challenge to the courts is to consider defining good faith in this fashion. If you're going to come up with a light duty job offer, it doesn't have to be meaningful, it doesn't have to be compelling, it doesn't have to be satisfying work, it could be boring work, it could be tedious work, but it has to be some kind of work that exists in your jobs, in your business operation, that an able-bodied person might do. So if you're going to give a light duty job offer, it must be something that potentially already works within your business operation. So if your business operation involves you've hired somebody and you've purposely hired an able-bodied person, and there's no accommodated work where that person goes to a room, sits in a wheelchair, stares at the wall, and looks at a clock all day, and then you can maybe make an argument, well, hey, this is something within our operation that we're doing. But if there's nobody, if you would never hire anybody to do that thing, sitting in that wheelchair, then I would argue not good faith, because it's not a job that you would give to an able-bodied person, or it's not a job that exists with your business operation. So that would be my challenge to the court as to what a way to define what good faith would not be in regard to a job offer, because this just happens all the time. So in fact, the individual who was sitting in the wheelchair didn't have any reason to be sitting in a wheelchair. So the whole purposes of sitting in the wheelchair is to just make that person, basically denigrate them, make them look like a fool or look like a wimp or whatever. And so everybody could look at the malingerer sitting in the wheelchair. So this guy didn't actually injure his legs. There was no mobility issue. It was the hand, I believe. But the Pacheco case, similar situation, and I talked about that in a prior video, but basically this guy did have an issue with walking. He had like major problems with his foot, and they stuck him, the employer, and it was like a factory or something. So what they did is their light duty thing would be they would stick their light duty people in the cafeteria, and they might have been doing paperwork, but it's not really entirely clear on that. But they would stick them in the cafeteria, and essentially everybody would be walking past this person, and they would look like a goofball. And then, so what ended up happening is they had these hearings, and the employer brought all these witnesses that said, "Oh, that's just normal. That's the way it happens." And but I would argue that's very bad faith, and I'd argue that is a bad faith, and it's the whole purpose of that is to one, humiliate the person, and then two, set up a situation where they're either going to fail some kind of workplace rule violation by dint of the fact that they're going out of their mind from boredom, from doing nothing. I actually had an injured worker who was stuck in a back room, and it was bizarre. I mean, at least they're kind of doing something that would use their brain, but they would do like read brochures on various weird milieu of sundry things like forestry and first aid for scuba divers. And by the way, this was a temp agency, so what would first aid for scuba divers or forestry have any relation to the the jobs that the temp people are doing? I would say probably zero. Alternatively, like what it might be like an example of a good faith job offer would be, I had a guy who was working on construction in some capacity, and when this individual got injured, they put him in the office, and he was tasked with coming up with toolbox talks and kind of safety procedures and going over these things, and then and collating this information and putting on presentations for the rest of the workers in the company. That seems like something that would benefit the company, and something that if he's not going to do it, then somebody else in the business is going to do it. It's part of the business operation. So that's what's coming up. But if you have any of these situations, just understand the reason why you're being stuck in the table looking at the wall is they want to boot you out. So they want to terminate you. Once they terminate you for cause, then they're going to make the argument based upon this 412356F. The second sentence in that code section is, hey, this person was terminated for cause, had nothing to do with their work injury, even though they're working with restrictions, and they're, the reason why they're in that chair in that situation in order to fall asleep or access their phone was because of work injury. But they'll probably prevail, and then you're gonna be out of a job, and then you're not gonna be able to get unemployment, and then two, you're not gonna be able to file for a temporary total disability. So if you run into any of those situations, this is a developing area of law. We might have some kind of clarification as to what good faith means by either the Supreme Court or the 10th District following this Pacheco thing. But right now, the Supreme Court has refused to define what good faith means. They've given an example of what good faith would not be. And the one example, the hard example that they give is an employer gives you a light duty job offer that they know you can't undertake. So for example, if the employer knows that you have kids and you have to be at home during the day in order to take care of the kids, and they give you the day shift, and that's the only position they give you, they know, or they should know, or you might be able to prove that they knew that you wouldn't be able to take that light duty job offer, and in that case you refuse. So then, but irregardless, when you're in a situation where you've gone off work, or you've been off work, and your doctor's releasing you back to work, you're getting in the danger zone when you're working with restrictions. By all means, you should always be trying to get back to work, either in a restricted capacity or in a full duty capacity. But understand, when you're in that restricted situation, you're always in the fishbowl. You're always got to dot your I's and cross your T's, and if you don't, you could be in danger. So if you have that situation, as always with every video, I always 100% recommend that you contact a workers' comp attorney. Search on the internet, look on, contact your local bar association, Columbus Bar Association, Ohio State Bar Association, Cleveland Bar Association, Dayton Bar Association. Call them up, say, hey, I need a referral, and hopefully they can refer you. Or ask your friends, hey, you got injured, who do you use as your workers' comp attorney? Who can I talk to? You should be able to find somebody. And with workers' comp attorneys, the initial consults are free, so they could review your situation and kind of possibly give you pointers on what you may or may not do. Otherwise, you really should get a workers' comp attorney involved with your situation. And we are all paid contingency fee, or most of us. So that's what I recommend. But if you have any questions or concern about this, or about any videos or anything, contact, you could leave questions in the comments below, or you could email me or call my office. So that information is always available in these videos. Anyways, stay safe. No work injuries. If you have a work injury, get better as soon as possible. Get back to work if you can, and get your surgeries and all these things. Otherwise, thanks for watching. You've been listening to Attorney Kip from Malek and Malek. Thank you, and I'll see you in another video later on. All right? Cool. Thanks.